Yes, Mr. Ganguly.
Dennis.
In this case, we are absolutely in the mercy of your lordship. But
No, the
before taking any
only question is that
point of view, my lord,
why the officers, why the persons who have destroyed the record be not prosecuted under section 204? Now that is the only question.
if you want
Because admittedly, two suits are pending, two proceedings are pending, one civil suit and one session trial.
absolutely your lordship.
Not some summary trial or not some summon trial. It was a sessions trial which was pending, and you proceed to destroy the case diary. You admit it is wrong.
If you
So why we should not direct the trial court to take decision under section 204 IPC and to pass the necessary orders? Or we should pass the orders here itself.
for that limited purpose, my lord, and one or two more facts, my lord, if your lordship permit, my lord, then I will
बताइए.
do some. Section 204 is being seen in this context, my lord. Then one of the word, my lord, intention is very important. Then
So that will be a different issue. That will be a question. That will be
that is to be seen by someone, my lord.
seen by someone, so that the IO will see.
My submission is that
IO will see. He will be having a right to file protest petition.
my submission.
If the IO comes to a conclusion that no, there was no mens rea,
For that,
for any crime, mens rea is necessary.
yes, my lord. For that, my lord, if your lordship permit, my lord, then the superintendent of police can hold an inquiry in this regard. And if there is something fishy on any of the person's part, my lord, whether it's a committee, my lord, we can.
अच्छा डायरी मिल नहीं पाई कल आपसे कहा था ना, देख लीजिए शायद कुछ कागज कहीं रखे हों, डुप्लीकेट कुछ हो मिल जाए.
दो बड़ी बहुत क्रूटल चीजें मुद्दा. एक तो सर जो इन्होंने एमसीआरटी फाइल करी थी सर, जो इनके फेवर में अलाउ हुई, वो हमने ईडी ऑफिस से पूरी फाइल ढूंढवाई थी.
इसमें केस डायरी नहीं होगी लेकिन.
है फोटोकॉपी है.
अच्छा
यदि आप चाहें तो सर एक मिनट.
अच्छा, आपको क्या चाहिए केस डायरी?
मतलब केस डायरी पूरी चाहिए फॉर द पर्पसेस ऑफ प्रोसेस.
इसमें जो पर्चे लिखे जाते हैं, पर्चे थोड़ी होंगे.
सर पर्चे के एक केस मतलब वो 172 सीआरपीसी में तो पर्चे से तो मतलब एविडेंशियल वैल्यू नहीं रहती, लेकिन करस्पॉन्डिंग ओरिजिनल जराइम रजिस्टर हमें मिला. सीडी में तो थोड़ा डिटेल रहता है, लेकिन जराइम रजिस्टर में भी इक्वल सब एंट्रीज हैं जो
सीडी सेक्शंस होंगे और कौन एक्यूज्ड है इतना सा होगा जराइम रजिस्टर में.
हाँ, मतलब थोड़ा यदि कुछ कोलैबोरेट करना चाहेंगे तो वो जो सीडी में एंट्री होंगी वो हमारे जराइम रजिस्टर में ओरिजिनल हमारे पास है.
Mr. Sanghi, what do you want from the
6th of July 2012, the petitioner was taken under handcuffs to the police. I objected to it immediately on that very day. The learned CJM passed an order after giving them an opportunity on 3 hearings, and they did not file any reply. Ultimately, he passed an order कि आगे से इनको हथकड़ी में ना लाया जाए. This was the order, against which I have filed a suit under law of torts. My allegation is that at the behest of respondent number 9 and 3, all this activity has taken place. When I put जावक डाली थी, इतने न्यूज़पेपर्स हमने फाइल किए.
What is the role of 9 and 3?
Pardon?
What is the role of 9 and 3? Were you having some transactions?
9 was the CSP at that.
No, they are officers. You say at their behest.
At their behest.
Did you have any transactions with them?
No, I did not have any transactions, but they were working under a higher up, some political body. And therefore, they were instigating all these things that that person must be taken in under handcuffs. Let him be produced in handcuffs.
You want to prove that you were taken in handcuffs?
I was
How
taken
can
in.
Prove by the diary?
In the diary, आवक जावक में है वो, और जो हमने उससे
आवक जावक में क्या है?
हमने उससे क्रॉस एग्जामिनेशन में पूछा कि ये आप इसको कब लेके गए, वहां पे कब लेके गए. फिर हमने बहुत से जो पेपर में जो फोटोग्राफ्स उन्होंने पब्लिश कराए हैं पुलिस
डायरी में, ये थोड़ी आएगा कि हैंडकफ में ले गए.
मतलब हैंडकफ का ऑर्डर यहाँ इन्होंने केस डायरी में लिखा होगा कि उनको हथकड़ी लगा के लेके जाना. मैंने वो सारा रिकॉर्ड पेश किया. आरटीआई में निकल रहा है
हथकड़ी में लेके जाना,
हथकड़ी में लेके जाना, क्योंकि हथकड़ी इन्होंने जारी करवाई है वहां से. वो मैंने आरटीआई में पूरा रिकॉर्ड पेश किया है. तो वो इसमें केस डायरी में होना चाहिए. वो
होना चाहिए. एसपी का ऑर्डर,
एसपी का ऑर्डर भी हो सकता है और सीएसपी का भी ऑर्डर हो सकता है. फिर सीएसपी खुद कई बार गए हैं इसके साथ, एक्यूज के साथ, डिफरेंट प्लेसेस पे. कि वो प्रॉपर्टी जिसके बारे में विवाद था, जिसकी वजह से इनको अरेस्ट किया गया, उस प्रॉपर्टी के स्पॉट पे कई बार गए हैं, इनके ऑफिस में कई बार गए हैं, इनके घर पे कई बार गए, इनको लेके और पेपर में पब्लिश कराया वो। नंबर 9 ही हिमसेल्फ वेंट देयर। जब मैंने क्रॉस एग्जाम में पूछा उनसे, तो जो पेपर जो हमने न्यूज़पेपर्स फाइल किए थे जिसमें ये सब पब्लिश होता था, उन न्यूज़पेपर्स में पहला न्यूज़पेपर उन्होंने एडमिट कर लिया कि हाँ मैं ये दिख रहा हूँ। बाकी में
an order of the SP to take you under handcuffs.
मतलब I got the information from the police personnel only कि ये उनका आदेश है, हम क्या करें, क्योंकि जब मेरे को हैंडकफ में ला रहे थे तब मैंने कहा,
आदेश तो ओरल भी हो सकता है,
मतलब तब मैंने कहा कि मेरे को क्यों लाया, इसीलिए केस डायरी
पर भी हो सकता है कि ऐसे करना है।
that could have been a point of discussion at the time when my application under Order 16 Rule 6 was filed, called the case diary. That order has been passed in my favor that yes, case diary be called. And that order remains unchallenged by the other side. That has attained finality. So
now they said that record is not there, destroyed, erroneously destroyed.
So, Milord, my humble submission is that it is a deliberate attempt when the sessions trial is pending, number one. Number two, one of the accused persons, Ashok Kumar Malaram, is absconding and there is a Gair Meadi warrant against him. Third, an application under section 319.
Police regulation 703 or 706?
Pardon?
Yesterday you were referring to police regulation, some clause.
703, Milord.
706?
703, Milord. Most probably. I'll just... 703, Milord. Record elimination. The following registers shall be retained for the previous periods showed. Number 2, case diaries A, B, C, D. D says case diaries in which action under section 512 CRPC has been taken 20 years. This is corresponding to section 299 of 1973 code. And in 5, subclause 5, it is said other case diaries 10 years. And exception is diaries of cases.
वो लेटर है क्या हैंडकफ वाला?
नहीं सर, ऐसा तो कुछ
नहीं है।
एक निवेदन और यदि आप परमिट करें सर, उन्होंने सर जो ऑर्डर चैलेंज किया है P1, उसमें सर ऑपरेटिव पार्ट पेज 23 के लास्ट में है सर ये कहते, इसमें लिखा है सर, उभय पक्ष के तर्क का अवलोकन में अभिलेख के अवलोकन से प्रकट होता है कि आरक्षी केंद्र ओमपी के प्रभारी द्वारा न्यायालय के समक्ष सूचना प्रस्तुत की गई कि अपराध क्रमांक 252/12 की केस डायरी नष्ट कर दी गई है। इस संबंध में पुलिस अधीक्षक के सामान्य आदेश एवं केस डायरी नष्ट करने वाली समिति की जानकारी भी प्रस्तुत की गई। आरक्षी केंद्र के प्रभारी निरीक्षक द्वारा
यह भी लिखाई देते हैं, इसमें लिखिए by way of present petition, the petitioner has called into question the order dated 21. किसका ऑर्डर है?
21/3/25.
21/3/2025.
10th District Judge Jabalpur.
Passed by the trial court, whereby the trial court has refused the application, has turned down the application of the petitioner.
It is 1/4/25.
पहले 1/4 ही लिखाया था। 1/4/25, whereby the trial court has turned down the request of the petitioner to call for affidavit of concerned officer of police to submit affidavit in respect of destruction of case diary. Next, the petitioner has filed a suit for seeking compensation/damages in the matter of he being handcuffed by the police authorities without any reason to put him under handcuffs. Point. It is the case of petitioner that the suit is pending since the year 2013 before the trial court, and in the intervening time, in the criminal case in relation to which he was illegally handcuffed, the petitioner had filed application for quashing the criminal proceedings which were registered as MCRC
14642 of 14.
14642 of 2014, which was allowed by this court by order dated
24/6/20.
24/6/2020, and the criminal proceedings only against the petitioner were quashed. Point. However, the sessions trial for the offences under sessions trial arising from FIR for offences under section, वो section कहाँ से मिलेंगे? MPRC के order से
The section.
under sections
मिल गया सर MCR से order
420, 467, 468, 471 and 120 capital B IPC is still pending in ST number 419 of 2013 before the Sessions Court at Jabalpur. And further, one of the accused persons therein, namely
Ashok Kumar Malaram.
Ashok Kumar Malaram, is still absconding. Point. Next, it is the case of petitioner that to show that the petitioner was illegally handcuffed under orders of a superior officer of police. He had filed an application under Order 16, Rule 6, Order 16, Rule 10 and 20, CPC, read with Section 151 thereof, seeking to produce on record the case diary of investigation of crime, so that the order of superior officer of police to put the petitioner under handcuff could have been brought on record. Point. ये कब allow हुई आपकी application?
Look, that was allowed on 12/12/24.
उसका order कहाँ है?
Look, that is annexure P5 at page 47.
Point. The said application was
46.
allowed on 12/12/2024.
It
And the
starts
trial
from page
court
46.
directed the police authorities to bring on to produce case diary of investigation of crime number 252/2012 for police station Omti, district Jabalpur. Next. However, in response to the said order, later on the police authorities came out with a plea that the case diary in question has already been destroyed by the police station on 10/2/2024, and the proceedings for destruction of case diary was produced before the trial court, which led the petitioner to seek affidavit of concerned responsible officer of the police in the matter of destruction of case diary, which was turned down by the trial court. And now the petitioner is before this court under Article 227. Point. Next, it is the case of petitioner that by refusing to produce the case diary, the respondents have destroyed a material piece of evidence, which is a criminal act in terms of Section 204 IPC/241 BNS. Point. Next, this court BNS, because it destroyed the material piece of evidence which was relevant in the pending civil suit, wherein the police authorities have appeared and had filed written statement way back in the year 2015, and even the criminal trial is pending, and therefore the destruction of case diary was not permissible as per clause 703 of MP Police Regulations. Next, this court had directed the police authorities during course of these proceedings to seek instructions that under what circumstances the case diary has been destroyed. In response whereof, an affidavit has been filed by CSP Omti, District Jabalpur, namely Shri Tonu Kurmi, mentioning therein in clear terms that the diary of crime number 252/2012 was destroyed mistakenly, and it was not meant to be destroyed. Point. In para 10 of the affidavit, the following assertions have been made. ये ERP में 20 नंबर का डॉक्यूमेंट है, उसका para 10. Next, the police authorities, by filing the aforesaid affidavit before this court, have admitted that the committee has erroneously and mistakenly destroyed the case diary because because the authority was under impression that in petition under section 482, the prosecution against all the accused persons has been quashed, whereas it was quashed only against the present petitioner and against 8 other co-accused persons. Session trial was still pending, and that was a bona fide mistake. Next. The relevant provision permitting destruction of case diaries is as per 703, clause 703 of MP Police Regulations, which is as under. 703 quote kar dijiyega. Next. As per the aforesaid provision, where aforesaid provision, there is a specific exception regarding diaries of cases which are still pending, and where the and in respect of case diaries in which action under section 512 CRPC has been taken, the time limit is 20 years. Point. In this case, not only the case is still pending, firstly in the sessions trial, and secondly a civil suit is pending, but thirdly one of the accused persons has been declared absconder, which is an event in terms of section 512 of 512 CRPC 1898, corresponding to section 298 CRPC 299 CRPC 1973. Next. The counsel for the petitioner had vehemently argued that this amounts to destruction of evidence, which is a criminal offence under section 204 IPC/241 BNS. Next. The prayer made in the present petition is to call for an affidavit of the concerned officer of the police in the matter of destruction of case diary and to investigate into truth or otherwise of the declaration made by the police authorities. Point. Next, as the affidavit has already been filed before this court, therefore, this court does not deem it fit to further proceed with the matter and leaves to petitioner and leaves it open for the petitioner to raise all the contentions before the trial court by reserving all the contentions made by the contentions of the petitioner to be raised before the trial court, and the petition is disposed of with the following directions. Number 1, the petitioner would be at liberty to summon Shri Sonu Kurmi for cross-examination in the pending civil suit. Next, based upon the cross-examination of Shri Sonu Kurmi, the petitioner would be at liberty to move appropriate application before the trial court to issue appropriate directions in terms of section 204 IPC. Third, in case the case diary remains untraceable, the petitioner shall also be at liberty to pray before the trial court to draw as adverse inference based upon the contents of cross-examination of Shri Sonu Kurmi. Next, the Superintendent of Police Jabalpur is also directed to cause an inquiry into the intention and circumstances, intention of the officials and circumstances under which a case diary wherein 2 judicial proceedings were pending has been destroyed in violating the mandatory provisions of clause 703 of police regulations. Next, during course of hearing, next, with the opposite directions, petition is disposed.
Public.
Shri Rajesh Kumar.